Welcome, everyone, to this Legal Office Hours webinar. Today's topic, common legal diligence issues and how to handle them. My name is Will Smith. I'm the host of the podcast Acquiring Minds and a partner in Minds Capital, a fund that invests in independent sponsor-led acquisitions. Attorneys James David Williams and Bill Barlow are going to host this session. James David and Bill are partners in Barlow and Williams, a practice that specializes in small business M&A, lower middle market M&A. They're at the front lines of our market, and their focus is on helping searchers and sponsors like you all do your deals. They also represent sellers, so they know these transactions well from both sides. The way we run these is Bill and James David have a presentation to give. They will do that, and then we'll shift to Q&A. You can ask a question as we go, though. Use that Q&A button in your Zoom app. We have comments turned off or the chat turned off, so that's how you can submit a question. If you have a very detailed question, we probably won't get to it for the live event here, but you can submit it anyway, and time permitting, James David will get back to you after the fact with an answer. We are recording, as always. You will receive a link to the recording and to the slides by email later today or tomorrow. Sophia on my team is out for the week, so that email may be a little bit slower in coming this week, but you will get it. And in the chat here are links to James David and Bill's socials and their website. So connect with the both of them on LinkedIn. Send them an email and check out the website, Barlow and Williams, for Barlow and Williams. Okay, guys, over to you.
All right. Well, thanks everyone for coming today. So the topic is going to be about common legal diligence issues and how to handle them. A little bit of a preface. As Will said, we're Barlow and Williams. A couple things about us. We are a flat fee law firm. There's just two of us. When you work with us, you work with us. And like he said, this is stuff we do every day. So we're going to talk about these, and these are based on real world experiences that we've had in the last year. And we're just going to go through them. What are the things and what should you do if you see them?
So we'll start with something that's not exactly a legal thing, but is an overall deal thing. And that is just the financials for small business acquisitions. The financial reporting can have varied quality, I'll say. And, if you are spending millions of dollars to purchase a business, or putting up a personal guarantee for millions of dollars of debt to purchase a business, you want to make sure that the financials that you're presented and that you're valuing the business based on are accurate. So what that means is that often before we really even dive into legal diligence, you want to do the financial diligence. And so if you are spending, if you are doing an acquisition for multi-millions, it's worth spending the thousands of dollars to get a good quality of earnings report prepared. Because if you don't, it can just cause all kinds of problems later. And if things need to be adjusted based on the QOE, it's better to do it early rather than wait until later, because the longer it waits, the more deal risk there is.
So this is kind of like a basic thing in the transaction. Like a lot of other legal due diligence items we'll cover, in 95% of cases, it is an easy check the box. The seller owns it, or the seller and their partner own it. But in that, 1 or 2% of times where that's not the case, this can actually be a big issue. So understand who needs to approve it. If they're minority owners, they may have consent or veto rights. Sometimes that even changes around the deal structure. We had one deal where there was this minority investor that didn't want to do the deal, and we had to change it the seller was able to force them to do a deal, but only if it was like a merger and not necessarily if it was a sale of the asset. So we had to change around the structure. We did the deal based on the fact that there was this minority investor. There was a different deal where there was a different minority investor who was very antagonistic and was suing the company. And there we also had to change around the deal because of the minor the minority rights protections. And so just keep in mind this is a common thing. If that's an issue, it often needs to be addressed early on.
Okay, key contracts, and this is going to vary based on the target business, but almost always, not always, but almost always, sellers have key contracts. That could be a franchise agreement, could be customer agreements, could be a supplier agreement. Um, but whatever those key contracts are for the business, you want to get them, and as soon as you can so that we can start digging into them. One of the big things with, say, customer or supplier agreements is if the sellers, big customers or big suppliers are, family members or businesses owned by family members or close family, close friends of the seller, then it's possible that there could be kind of sweetheart terms uh, that the seller has that you aren't going to get post-closing, and those could materially impact the financial performance of a small business. So not that we've seen it, but we've definitely seen it.
Kind of along with that is, are contracts transferable? So um, you will commonly see this if your customers are, think governments, think universities, big nonprofits, think large companies. When that happens, it is often a difficult process to be onboarded as a vendor. And so, if you were to buy the assets and then try to get onboarded as a vendor, you would probably face a steep uphill battle. And so, in many of those instances, you have to change the structure to be an equity purchase. Um, Keep in mind, sometimes even if you're buying the shares, depending on how the contracts um, are written, they could have change of control provisions where even a purchase of the shares, is an assignment of the agreement. We had one deal where there was a Fortune 500 company on the other side, and the person seemed very offended that I even asked for a consent. It was very strange, and we had to deal with the fact that we have this major contract. They're not really willing to give a consent for whatever reason. So, just know if there are contracts like that, that needs to be addressed up front.
Yeah, I got the employee issue. So, dealing with this on a couple deals right now. So, um, if the seller has a large number of independent contractors on the workforce, 1099s, that could be a problem, right? It's if those people are actually employees, and the test as to whether someone is an employee or an independent contractor does vary by state. Some states are more aggressive on this than others. Massachusetts, California, New York, among some of the most aggressive. Um, but if the seller has misclassified people as 1099s and they should be W-2s, that means that they should be paying taxes, basically, and with doings, withholdings, and all of this. It's all tax related. Uh, Even in an asset purchase deal, if you hire substantially all of the workforce, right, then the state will consider you a continuation, right, a continuation of the old employer, and so that liability actually doesn't get discarded even in an asset purchase. So, if the seller has been doing it incorrectly and you fix it, there is still exposure. You definitely want to fix it if you find something, but um, yeah, it's not perfect. Um, I have another deal right now where payment cycles, how often employees are paid is an issue. So certain states mandate certain things related to that. So that's another liability that would carry forward. And verification on employee status. Um, this if the business, right, certain businesses have international employees or international contractors, but if we're dealing with a Main Street U.S. business, especially in the current political climate, but this was true even under prior administrations, you need to verify that the employees are legally authorized to work in the United States. The standard form for this is something called an I-9. The seller should have those on file. Often the seller will not have the accompanying documentation with the I-9, so it becomes a little bit tricky to diligence. That documentation would be a social security card or a passport. Some sellers actually do have scanned copies of the passports, but they should have, at the very least, have the I-9s filled out, because if they don't, then you have potential immigration issues with your workforce.
Other things that are important with employees is knowing what their roles are, their compensation, their benefits. The general practice is you're going to keep the same payments, compensation, etc. Now, keep in mind, one thing that is very common we hear from searchers is that after they have stepped into the business or as part of the discussions, a manager, employee, especially key employees, come to them and say, I want to be paid more, and a lot of times, you want this person and you want this person to be excited to work for you. And at the same time, you haven't necessarily worked with this person yet either. And so it can be a tricky situation, but you want to navigate that as early as possible. Another thing that's really tricky, this is one of the areas where sellers are most sensitive about giving you access until the closing. Now, we've seen a huge continuum. We have one deal right now where literally as soon as they signed the LOI, they said, I'm going to walk down and introduce you to my whole workforce. And they already have, actually, like right after, and they got to talk with them for a whole day, right? I have another deal right now where the seller has said point blank, you're not going to talk to any of my employees until closing, right? Until after closing. Now, that second thing usually just doesn't work, right? Because you need to at least get some sense of them in this working relationship. And we understand the seller is sensitive, but they have to understand that the further you go in the process, the more, it makes sense for you to have those conversations. Um, a couple other things just to know about is collective bargaining agreements. You might be surprised some of the trades can actually have them, especially if they're doing certain types of work. We've dealt with that a couple of times. There also can be defined benefit plans. Again, not something that's very common, but once or twice we've seen it come up. And when it comes up, you need to get a specialist and it becomes kind of a whole thing. So make sure to just take a look out for that. The other thing is, you should have a sense of what your executive team is going to look like, especially if there's like a key operator, a key salesperson. They need to be bought in to whatever you're doing for you to be successful going forward. So you want to really talk to them, and potentially you need non-solicits, potentially you need non-competes, because if they have key relationships, operational knowledge, they could start their own thing down the door, and you don't want them to do that. So these are all important things to keep in mind.
Okay, next, permits, licenses. Again, huge variance between different business models and geographies. Um, but regardless, you need to know what licenses are needed. Um, Usually the easiest way to start this is to ask the seller what licenses they have at present. They being the company and the individuals who work at the company, because sometimes licenses are held by individuals, other times licenses are held by entities. But you start by asking seller, what do you have? right? And then you go from there down various rabbit holes. And you want to do this early because if it turns out that there is a key license that can't be transferred or that you can't obtain and with a new entity, um, which happens sometimes. We had a conversation with a prospective client last week who had a really interesting scenario like this. Uh, but in any event, if there is such a transferability problem or you can't obtain the license, then it can impact deal structuring. It can force an equity purchase.
I'll also say there's one other thing that kind of gets lumped in sometimes with licenses called certifications. So this is common in manufacturing where you have a certification that your product is meeting certain specifications. And that's something as well that you need to think about how that gets transferred. Oftentimes they'll have the certifying agency come down in an asset purchase agreement, and it's almost less about the entity, and sometimes it's about the actual, site and how they're producing it, and just to make sure that you get that certification going forward. So just keep in mind, you can also have licenses are generally given by governments. You can also have certifications that are given by private entities that will also need to think about how those are handled.
Yeah, and another consideration for licenses in particular in the SBA context. If you are doing a total buyout in the SBA context, then you will not be able to rely on the seller as a qualifier or license holder in most circumstances. Because if you're doing a total buyout under SBA rules, the seller cannot be an employee post-close. And so in a lot of these licenses, even if you can get the entity can get a license based on an employee having the license. Well, if you're depending on the seller, then because of SBA rules, the seller can't be an employee. So sometimes those don't work. I've had that conversation with more than one person since those SOP updates.
And James David, just since we're on the topic, what about partial buyout as a solution to that? And if you define partial buyout?
Yeah. And so partial buyout means that you buy, say, 85% of the business instead of 100%. So this is only in the SBA context. That can work. And we've seen deals done that way in SBA land, often in the trades, because that's usually what we're talking about for this particular circumstance, but doesn't have to be. But if you go that route in the SBA context, there are additional things that must happen in order to fit in the SBA box. Number one, the acquisition must be an equity purchase, not an asset purchase. And so that means, amortization is different, liability is different, right? A number of things are just different for you as the buyer. Number two, the seller will have to personally guarantee the SBA loan for at least 2 years in that situation. And depending on ownership structures, could be longer than that. But it's at least two. And it's at least, it's not a set two. If you get behind on your payments, then that clock resets. So as you might imagine, a lot of sellers are hesitant to personally guarantee a loan of that sort of magnitude where they're a minority shareholder and now they aren't in the operator's seat. So have we seen them? Yes. Is it common? Not really.
Yeah. So just to underline there, last summer, the SBA made it very difficult for a seller to essentially roll equity to take a small percentage and carry it forward with you as the buyer, which used to be the way to deal with this. That's been made so onerous and unattractive to sellers that it's very rare that they'll do it these days.
Yes. And one of there's, if you're outside of the SBA, there's multiple ways to achieve it. And in the SBA context, they took those other things away. So you're stuck with one option.
Yeah. Another issue that comes up very commonly is real estate. If you're buying the assets, and sometimes even if you're buying the equity, you will have to get an assignment of the lease, or, even if it has a pre-existing lease, it has to be the 10-year term if you're doing the SBA. So, um, you need to get a sense of what the plan is for the real estate. We've seen multiple deals that have died because the real estate, one landlord simply was not willing to assign the lease. And if that's a problem, you would much rather know that earlier rather than later, because the worst thing is to go through all of the QOE expenses, all the legal expenses, come to the end, and the landlord says no. So this is something where you want to have this conversation early. You also want to have this conversation if you're buying the real estate from the seller, because that tends to lengthen out the process. Um, some of the questions, has there been any phase ones, especially if you're dealing with a company that's not an office space, but an industrial space, something manufacturing, the SBA is basically going to require you to do a phase one, and they do some preliminary testing. And then based on those preliminary testing, you may need to do a phase two. It's not too common, but we've seen it happen on these deals, and that will prolong the process by another month. The seller will get often irritated. It's extra expense, and so you need to just make sure that you are being very proactive about that. If you're buying real estate and it's an industrial, manufacturing, etc., especially there, you need to be on top of the fact that you need to get those environmental reports done. If they already have phase ones, that's also a great thing. So sometimes they'll identify if they're underground storage tanks or some other thing that might cause a phase two. So just keep that in mind because it really can impact timing.
Okay, next is registered intellectual property. So there is a difference here between registered and unregistered, actually. But when we say registered IP, what we mean is like patents or trademarks that have been granted by the trademark office or copyrights that have been granted by the PTO. Um, the process for transferring them is a little bit different. Depending on what it is, patents can take a very long time to actually transfer. So you do license agreements in the interim. Trademarks, it's a little bit quicker. Um, you One of the things that can happen here too is that you'll find out that well, and when you diligence these, you'll find out that a lot of times the seller individually will hold the patent or the trademark and not the business. And so you have to be really careful with this in an asset purchase structure to make sure that you are actually getting all of the assets, even if they're owned by the seller individually and not by the business. There are ways to handle that. But you want to find this out early so that you can get in front of it. There can be sometimes people have brands that are trademarked in multiple jurisdictions or patents in the US and Europe. We've encountered that, right? The rules, right, are just the processes are just different in different places. Um, there's also, you have to renew these filings. So you don't want to make sure, you want to make it so that you know when you got to submit the renewal. That way you don't lose the patent or lose the trademark. Patents are a little bit different, but so you don't lose the trademark. Um, it's how the joke about how Mickey Mouse will never be part of the public domain. Um, well, this Disney didn't miss any filings, but Keurig did miss a filing with the K cup, and it wasn't great for their business going forward. So you'll want to make sure that it'll be a table actually, like this trademark and the renewal date, that sort of thing. But in any event, at the start, you just ask, like, do you have any registered IP?
And I'll also give a shout out for some unregistered IP. So the most common unregistered IP, there's two. One is you might have marks that are unregistered. So, you might have a logo, but you haven't formally registered it yet. Um, if it's generic, sometimes you can come into issues. So like if you have one that's, for instance, HVAC Heroes, right? There might be a dozen companies that are all calling themselves HVAC heroes, scattered across the US. And we've seen situations where there is they have a mark, they haven't registered it, and they're using it. And we had a situation where 6 months post-closing, somebody else who had registered a similar mark came in and said, "Hey, this is our mark." And so in that case, the owner had just, he'd flagged the risk. The owner had said, "Don't worry about it." Um, and he accepted that risk, but that's what happened, right? And that's what can happen in those sort of things. Um, Another thing you can see is copyright, which in for business acquisitions most often will include code. Um, if you have a software component where you're actually developing code and, software as a service business, something along those lines, then there'll be pretty intensive diligences to making sure that the people writing the code actually assign that over to the company. Now that's not something that's usually registered. It's almost never registered, but it is something that becomes a diligence item. So if you have a target that is developing software, then you do need to make sure that the people actually doing the coding will have given that code to the company.
And that is the biggest problem. When that is the biggest problem, it tends to be when there's overseas development, software development shops involved. Uh,
Yeah.
at least in our experience in India. Uh, but that's limited experience. So.
Next one is pretty straightforward. Are you buying into a lawsuit? And we say, is there an active or threatened litigation? So, one of the nice things is we can do a litigation search to look to see if, people have filed litigation in the county, federal, or in the location where the company is. But it also can be the case that people can threaten litigation. They can send letters. They can basically say, "Hey, if you don't do this thing, I'm going to sue you." So you want to make sure that you understand what that is. And frankly, even if things have been resolved, it's good to know about them because you might get a sense, hey, is this an ongoing issue, right? Is the company getting sued by its customers because it has shoddy workmanship, right? And if that's the case, you might anticipate that that would continue in the future. So it's something that you should know about. A lot of times, what you will find is that if there is um, an active litigation, you will have a special indemnity. Basically, you are going to set aside, the seller will indemnify you for everything related to that lawsuit. And sometimes your lender might actually require them to set aside a portion of the purchase price into an indemnity escrow until that has been resolved. We actually saw that in one deal this year, where kind of towards the seller insisted that it wasn't a problem, but the lender said, no, gotta have a special escrow just for that lawsuit.
Yeah. And you also want, this is not directly related, but things like loss runs and workers' comp history. Uh, Workers' comp claims, if there's a lot of them historically, then it can jack your rates up going forward, even an asset purchase, depending on the state, because sometimes you assume that history. But if there's a history of a lot of workers' comp claims, you want to know about that too. Uh, Other things, do third parties have claims on the assets or the equity? There could be a claim on the equity too, right? But most commonly, it's on the assets. And what this relates to is something called a UCC lien. So if you have a debt, it can be secured. And if you're doing an SBA loan or any other kind of loan, right, your lender will secure the assets as part of the purchase. And for the lender to get comfortable, then they need to be the first priority lien holder, which means that any other liens that existed before get cleared. Um, so there's databases of these. So we run searches to see if there are liens. They just need to get cleared or paid off at closing, prior to closing. Sometimes they'll get paid off at closing as part of the disbursement, and you'll get something called a payoff letter from the creditor. Um, that doesn't happen as much in the SBA context, but it can. But the sorts of things, like I did a search this week on a target for a current client, and the seller probably didn't even remember this, but the seller has a line of credit from, I think it's Chase Bank, one of the big lenders, right? But because they have a line of credit, the bank slaps a UCC1 on all the assets of the business. We're looking to buy all of those assets. So obviously, as the buyer, we're going to have the seller take care of that, right? Close out that line of credit and get that lien cleared. So tends to be just kind of technical stuff, but can also be a real issue if there are lots of creditors and if the seller has a ton of debt. But in any event, you need to know what you're dealing with.
Another question is about tax liabilities. So, even in asset sales, there are things that can carry forward. Sales tax, we also talked about employment tax. If you're doing an equity purchase, there's income tax, federal income tax that carries forward. And sometimes this actually changes how you do a structure. If you have an S corporation that you're looking to buy, even if you're buying the equity, you often do something called an F reorganization so that you shed the liability from when the seller was, an S corp in case they misclassified that essentially, right? That's one of the advantages is it helps protect you from that. So you want to understand your potential exposure, and especially if you're doing an equity purchase, you want to make sure that you're doing a lot of good tax diligence to make sure that they've been paying their taxes correctly. So it's unlikely that you're going to get an audit from the IRS or anything like that.
And tax diligence tends to be separate from the quality of earnings that we talked about at the start. I will say sales tax in particular, um, because of Wayfair versus South Dakota was the name of the Supreme Court case. It's been several years ago now, but the rules are different for every state and they're changing all the time with sales tax. So the easiest thing is actually just have software handle it for you. But if you are engaged in, say, any sort of e-commerce, sales tax becomes a huge diligence issue. And even if you're not, right? But if you're doing brick and mortar stuff, it tends to be easier. But if there's any sort of e-commerce component, sales tax can get very complicated very fast.
Is I
Go
actually
ahead. You can talk insurance. I don't.
fun as that is. Um, So this is a question you'll often have specialists come in to help you assess what the insurance package you should have going forward. Because if they're underinsured, then you need to model out what it would take what are the expenses to get the right insurance. Um, you also need to know this because there can be contracts either with landlords or with key customers where you are required to have certain amounts of insurance, and you need to make sure that you are adequately insured for those contracts. So this is something you'll often work with specialists on, but it's kind of quasi-legal as well. And the main thing is to make sure that if you are paying more than what they're currently paying, put that into the model to make sure that it still makes sense from an economic perspective.
Yeah, and it's maybe not surprising, but it's very common that there's a mismatch between the level of insurance the seller has and what's required under a lease. Um, and so that creates a technical default, and then that just invites the potential of issues. So there we go. So that wraps up the presentation. Thanks for listening. As Will said, we're going to start the Q&A. I will say, if you are using the Q&A, because I do answer all of those, make sure that you are signed in or that you put your email or name and email in the Q&A. Because if it comes in as anonymous and we don't get to it live, then I can't get you an answer later. So, but otherwise, we're Barlow and Williams. We do M&A exclusively. We use flat fees and milestone-based payments. And turn it back over to Will to MC the Q&A.
Thank you, guys. Thank you, James David. Great presentation as always. I've seen this presentation before, but I always learn from you guys, learn new stuff, even if I've seen it before. So thank you for another great one. Thanks to James David for the reminder about the anonymous. I'm supposed to be saying that in my intro. Somehow I always forget. It looks like we've had about 3 anonymous questions. So for you questioners, might want to, if we don't get to your question now, I might want to re-log in and re-ask it. Okay, bunch of questions coming in that have come in. Let's start with this one. Feels specific, but also could be learned from generally. So Brian says, hi team, I'm engaging with a business that has a diverse vendor certification. So like woman-owned or minority-owned or vendor-owned business that I won't qualify for as new owner. One specific customer of this business is a large public company that tracks and reports spend with diverse vendors in a public annual report. Okay. The current owner, seller, suggests that this client has never brought up that they've never brought up the status with this customer, and there's no specification in their customer contract regarding this specification. But are there any ways to validate whether this big customer knows about the certification, whether it matters to them? Are there ways to protect me if the customer decides to stop doing business with me because of the lost certification? The seller, and we can't do the obvious, which is the seller prefers not to approach the customer directly about this. Specific, but broad pattern there.
Yeah, a couple of points. One, you can draft a specific representation about this in the purchase agreement. I actually have done that in the last couple of weeks for somebody else, where there's a women-owned certification. So we've drafted language that has a representation related to this. What you can do in diligence, because you don't really want to rely on that. What you can diligence is just, okay, give me everything about the bidding process, right? Let me see the communications, et cetera, right? You want to look at the report if there is one publicly, in this hypo there is, but just get as much information as you can. And then there'll be a decision. Can there be special representation, special indemnities? Yes, right. There are mechanisms on the back end, but you would rather not have to rely on those. So maybe this is an example of just a general trend, right? The way legal diligence works, you will send a list of kind of initial requests. The seller will respond, and then based on those responses, you will have follow-ups. Right. And so this is a great area for follow-up questions to, dig in more on a particular issue that could be very important or even existential for the business. Right. So.
Great. Scott asks, I'm pursuing a business that currently has 4 owners. One of them was issued 15% equity as an owner-operator incentive. Are you guys saying that because this key employee is a part owner, that he wouldn't be able to stay on as an employee post-close?
So if you are doing 100% buyout, no, he would not be able to stay on as a owner post-close. If you are doing a buyout of the equity, it actually gets a little bit strange because the technical rules are if that 15% owner is selling any of their stake, they have to provide a personal guarantee. Now, if that owner is not selling any of their stake, then the rules, I believe, actually allow for some flexibility there, but you really need to talk to your lender because that's an area where the compliance officers are going to see, minority owner is, seller is remaining on, the seller must provide a personal guarantee, and they'd have to go through a pretty extensive exercise, probably talk to their own outside counsel to verify that they don't have to provide a personal guarantee. So the short answer is if that 15% owner is selling, if you're buying the whole company, that owner can't be an employee, period, full stop. If you're buying any equity from that owner, he's going from 15 to 10%, or he's increasing it from 15 to 20%, doesn't matter. That person can stay on, but they're going to have to provide a personal guarantee among the other things. If you are buying the 85% and that owner is exactly remaining 15%, then make sure you talk to the lender because they may not have to, but the lender is almost certainly going to have to like talk to outside counsel and get external legal opinion to certify that, which is always
Not
fun.
good. So
Yeah.
it's not a happy.
Yeah,
It's
it's a frowny face from whoever is your loan officer.
yeah,
So
it's not. Yeah, there's not a lot of flexibility in that circumstance.
yeah.
Is there any kind of fancy footwork where the existing other owners could buy him out first?
There's
There
a look
can
back
be, but
period,
yeah, but there are look back periods
I
involved.
see.
So it has to be done.
6 months, I think, at least.
It's either 6 or 12 months
Yeah.
in advance.
And audience, just on this point about the partial buyouts and any of the existing equity owners, i.e., sellers, rolling equity and having to take a personal guarantee. Personal guarantee is, just to be super clear about this, personal guarantee is already very unappealing, an unappealing feature of the SBA for many people. What this means is those seller who's rolling equity is personally guaranteeing, and they're not even the borrower. They're personally guaranteeing your ability to pay the loan. So
Yeah.
it's even an even more risky personal guarantee than the very one that you're taking because it's completely out of their hands. So that's why it's just like we treat it as a non-starter, despite the fact that I'm sure there are exceptions.
Yeah.
Okay. Let's see here. Oh, you guys have any recommendations for environmental assessment firms, vendors?
So we'll often, I mean, honestly, what often happens is they have to be local, because they will physically go out to the site. And so you should be able to find one nearby by doing searches, but that's why you don't have, the same way that we would have a QoE provider, several we could recommend. These ones have to be pretty local.
Yeah, and you probably want to coordinate it with the lender
Yeah.
if you're buying the real estate because they may have a preferred list.
Yeah.
Good. Scott says, I'm currently in due diligence and the sellers are paying regular staff, their GM and their front desk customer service staff as 1099s. We know we'll need to convert them to W-2s when we take ownership of the business. Does that have to be done from day one, or do we have a little grace period to effectuate that shift from 1099 to W-2?
If you're going to do it, I mean, one, you need to quantify your potential exposure, right? And the penalties there can be triple damages for some of these things if people are misclassified. Um, there could also be overtime issues, um, which wouldn't be the case for a GM, but could be for other people. And if they were supposed to be getting overtime and they're not, haven't been, then you could be facing double, triple damages with a 2-year look back period. Like it can get stupid expensive. Putting that aside, if you are going to make these changes, you do it day one, whatever it is. Like you operate in compliance the whole time because that sets you up to have a better argument with the state if it comes to it. and you're trying to reach a settlement with the state. But if you wait, then you lose that. It also cynically makes it less likely that employees notice a change if you do it at the time of acquisition because they're just like, well, this is the new boss, this is how we're doing it. So cynically, it's a little bit less likely that they would notice potential issues historically because they're like, oh, well, that was fine then, but we're doing it now differently. Uh, but I would also say if somebody is 1099 everybody, strong yellow flag for me that there may be other issues too.
Yeah.
Because
On this point,
that's usually a deliberate choice. Um, so
and James David, on this point about employees can be more receptive to a change if you do it early on, kind of just as part of the all the stuff, the commotion of a transition. But generally, though, employees should, to the extent they're paying attention, treat it as good news to be upgrade. It's an upgrade to go from 1099 to W-2, is it not?
often, some people don't think of it that way. Some people like to be freelancers or whatever.
I see.
Um, but yeah, I will say just generally because I had this conversation with somebody earlier. Uh, you need to have things like payroll in place. Payroll, you need to have your payroll provider in place to take effect closing day. There can be no lag with things like that. Insurance is the same way. These things must be in place, ready to go. You know, these providers, they'll get it, right? The closing date may be this Monday or it may get pushed to Wednesday. Like they understand that, but you need to have these things in place. There cannot be a lag.
Yeah. And most often I think you're generally right that people will, not be as likely to pitch a fit about that because they're having less tax liability. Because one of the reasons, frankly, why a lot of employers will do 1099 is because they don't want to be paying, you know, they're like, here, I'll pay this to you. And then, oh, you have to deal with your own Social Security tax and other tax and all that other stuff. And so, um, you know, anyway, it's really not very employee or independent contractor. It's not very favorable to the employee to be treated like a 1099,
Yeah.
which again, to James David's point, that raises a yellow flag in terms of the integrity of the seller, right?
Yeah.
He's basically offloading these costs that really should be borne by him onto his employees, you know. So
That, I guess, though, you guys also are highlighting there why an employee might not like being going from 1099 to W-2 because the paycheck they receive will be a lesser number
Yes,
because the taxes will already
there
be
will be
withdrawn.
there will be withholdings and the like, yes.
Yeah,
But they would actually come out ahead.
exactly. But
assuming
might
they
not
were paying
feel
their
like that to them.
taxes, yeah, exactly.
Okay, so did you say already if there is a gross misclassification of employees here, putting it on the seller to fix before proceeding with the deal? Why is that not a tactic?
They can be. I mean, sellers aren't going to do it.
Because it's a huge lift.
I've seen, well, I'm just, no, I mean, we've seen situations where if you properly classify people, all the profits go away. Um,
Oh wow.
so, yay, it's not a real business at that point. But I've seen it more than once. So, it happens. Um, but the penalties, the penalties can be, especially if it's like overtime, if people should have been, W-2s with overtime pay, right? That's time and a half they should have been getting. And then you're doubling it. Uh, you double it, you triple it with the look back periods. This varies a little bit by state, but the amounts can just swamp everything else.
Yeah, so from the seller's perspective, there are two risks, right? The one is if they do the change pre-closing, that's going to flag to everybody, hey, we're making a change, right? Which, it should also flag if you're doing it at closing, but sometimes because of all the other transition, it's a little less flagged. And the second thing is, you know, let's say that the deal dies at the 11th hour. The seller is stuck with having having to properly classify their employees, right? Which the seller might not want. And so, uh, you know, frankly, the seller should do it because that's what the seller should have been doing for in the first place. But if you ask the question like, what will a seller be willing to do? They're probably not going to be willing to do it um, prior to closing.
Yeah. Yeah. Makes sense. Um, and did you guys say that all of these the unpaid taxes relative to misclassification of employees carry through to you as buyer even in an asset sale?
As a rule, yes. That's not universal. Some states have statutes about this, California, but most places use a common law rule, and it hinges on whether you hire substantially all. Right. So if it turns out that you buy the assets and you're only taking two people out of a 20-person enterprise, then no, probably not. But if you're taking 18 of the 20, then you can assume that the exact enforcement mechanism varies by state. But it's basically a universal principle because if it weren't, then bad actors could just change the company, right? Change the company entity every few months and escape liability. And
Mm,
states aren't going to allow that, right? Because these laws exist to protect employees.
yeah. And in the vast majority of cases for searchers, they're acquiring, what was the language? Effectively
Yeah,
everything,
substantially all, right? Which
substantially all.
in the SBA deals is how it happens.
Yeah. And they're going to want those employees. That's always the fear of the searcher, is that they lose employees, not that they're not going to have enough with them. I think we devoted a whole other webinar to this topic, but Tim asks, might non-competes be requested by buyer to seller of a key employee or key employees prior to close, if such non-competes were not in place previously?
So
Yeah,
yeah, go ahead, Bill. I answered the last one.
yeah. So, you know, they certainly could. Regardless, you're just going to have to put it in place as of the closing, right? I mean, they might decide, yeah, oh wow, that's a good idea. We should do it. But in some sense, it's usually unlikely that the seller likes to change very much about their business, right? And so it's more that you're saying, hey, as of closing, go forward, I need to have that non-compete, non-solicit, whatever. It's rare, even if it's a good idea to have a non-compete, non-solicit, it's rare to have. I'm not sure I've ever seen a seller that has said, "Oh, I'm going to get this in place, for my own benefit, prior to closing," just because
And
it's
yeah, that doesn't happen. But there's
yeah.
also wide variation in non-competes across states. Um, California famously doesn't allow them for employees. Other places, there's uh, minimum salary thresholds that must be met. Washington has one of those, for example. There can also be time-based requirements in, I think it's Massachusetts. You have to be employed for a certain length of time for a non-compete to become enforceable. And then other places, there's dealing with one in Illinois right now where we have to get the employment agreements to the employees 14 days in advance of closing because that's a statutory requirement in Illinois. That's not related to the non-compete. That's just a separate thing. Other states have similar requirements at different lengths. So just a lot of variation by state on that particular issue.
One other point I would just say is that non-competes are issues that are often really sensitive for employees. On more than one occasion, we've seen a seller that said, "Hey, if you put this non-compete in front of my employee, they're going to react very negatively, right? And then you can sometimes have a conversation about whether or not you are really care more about the non-compete, which is you can't do this kind of business, or the non-solicit, which is you can't poach my customers, employees, and other relationships, right? We sometimes find that if, an employee is they generally are much more willing to do non-solicits than non-competes. And so, if the seller tells you, "Hey, my employee's going to have an allergic reaction if you give them a non-compete," if you really only need a non-solicit, sometimes you listen to that and then you kind of tailor it accordingly.
Non-solicits are also much easier to enforce.
Yeah,
And
And
that,
it feels more palatable too, because
but
it feels fair. It doesn't feel like you're trying to tie my hands or affect my professional future. It's just like, don't come poach my clients or employees.
exactly.
and that's why they're more enforceable.
Yeah. And so we did do one of I guess it was back in March, employee issues and non-competes. We did or you guys did a whole webinar on that. Maybe it's time to do that one again.
Yep.
I think that one's coming up
Yeah,
actually.
I think that's our next month's webinar, actually.
There we go. Yeah, last March and this March makes sense. Good.
Yep.
Um, international employees in quotes essentially 1099s. They don't receive 1099s, but a full-time person, according to kind of many US states, it would check the boxes of effectively an employee, but they're abroad. What about that? Is that just outside of the jurisdiction, so it doesn't matter?
No, it can. And there's some variation in what country they're in, actually. Um, but a lot of times you will use, and you'll do it through a platform that takes care of the compliance, is the short answer.
Oh,
But that's commonly how it's done. But I won't name them, but they do exist. But there can be um, circumstances, and you collect, it's a W-8B, and right there's tax forms you collect from these people in that event. But a lot of times you hire something called an employer of registry, employee. I
Sure.
don't know the name of it, but it's a you end up entering into a relationship with an entity that exists in that local country and not necessarily with the individual directly. So an employer of record sort of situation where you, as the business, kind of have uh, a contract with this company in the Philippines or Colombia or Mexico, wherever it is, and then that entity is the one that actually employs the individual.
And I will say it's generally a lot easier to deal with that than, US employees that are misclassified. US employees that are misclassified is a much bigger issue. Foreign workers, it's generally much easier you know, to do things and do it the right way.
but I'm
Does
not supposed to be paying Social Security for my foreign workers, am I?
no,
Right, exactly.
right. But there we have seen situations though where people weren't doing the compliance right for foreign workers, and if they were, then all the profits went away. So you do still need to verify it, even if that was an unusual situation where all the workers were overseas, and I don't remember the exact thing that they weren't doing correctly, but something was glitched with the system. I think it was that they weren't doing what I described. They weren't doing the employer of record situation, and if you actually did that in a compliant manner, then labor costs shoot up and the profits go way down, and the whole thing fell apart very
Ugh.
shortly thereafter.
James David, was there some reason you didn't want to mention the vendors, the kind of SaaS companies, service providers who will do all this compliance stuff for you if you're not doing the employer of record model?
Well, I mean, they set up the employer record, but there's different ones based on different parts of the world.
I
So,
see.
I mean, we use one of these ourselves, right? So, um, but there's variation.
Yeah.
Okay. We have a couple other questions in here, but they're pretty involved. So since we're at time and they're all non-anonymous, we'll call it. And James David, maybe you can get back to them. It's 3 or 4 in here, I think. Any last thoughts, gentlemen?
Well, we thank you guys for coming to see us. Again, we're Barlow and Williams. We're a flat fee M&A law firm. You work with us, you work with us, and we're always happy to have you look at our website, reach out. We have got a free LOI template. If you so yeah, we always are happy to serve as a resource for you guys. So
Just put into the chat, James David and Bill's links, their emails if you want to get that LOI template, and their LinkedIn. So connect with them there. And we were recording, and we'll get the slides. I don't think I got them from you yet, Bill. Sorry if I did. I'll check. And so we'll get all of this out to you, the slides with this recording audience in the next day or two. And watch for next month's webinar, which will be on employee issues and non-competes, it sounds like. So we'll go deep on that one. And that's it. Thank you all for your attention. Thanks for coming. Bill, James, David, thanks for another great webinar. And this ends this one. Bye.